And Nancy, if there's anything that, if people have questions, I'm comfortable jumping
Okay.
in as we
That sounds
go,
great.
or, yeah.
All right. Good morning, everyone. How are you today? We are here to present. We have Miriam Sievers with us from Amos Perrick Law. And Miriam here is to talk about with us about independent adoption. Miriam is been with the firm, worked, well, first of all, Miriam is very well versed in the area of adoption. She works in all areas of family law. Her practice involves LGBTQ family law and appeals. She is trained in collaborative practice and is a best interest attorney. She represents individuals going through divorce, custody disputes, and separation, and both settlement, negotiation, and litigation. She also assists couples in creating prenuptial and post-nuptial agreements. So what we would like to do is just a little few housekeeping rules. I want to let everyone know that we will be taking questions via the chat. If you have any questions during the program, just place them in the chat and I will be monitoring those to make sure that we address everyone's questions. We'll have a little bit of a discussion at the end about MVLS and we'll get this started. All right, so I am going to begin the program if you'll just bear with me. Are you able to see this, Miriam?
I am not.
All right, here we are.
Just a moment.
We're set up to go. All right, Miriam, take it away.
Okay, and just a moment, because I am trying to see your screen.
Let's make sure that's on. I thought I did, but
Can everyone else see the slides? You guys want to put it in the chat?
They may not be able to either. Let's just see.
Well,
stay with me.
I'll stay. There we go.
How is that?
That's perfect.
Okay, wonderful. All right.
All right, very good. Well, good afternoon, everyone, and thank you for being here. I hope that this will be informative, and what you will find as we go through the presentation is that I've put some of the text from the rules and the code into the slides. I didn't want to bore you all with all of the, parts and putting it as text in the slides themselves. If you have questions as they come up, please feel free to put them in the chat, to raise your hand, to do anything like that. We can be as, dynamic in this presentation as suits you all. And so without further ado, happy to go through sort of the adoption process in the state of Maryland for independent adoptions. If I could have the next slide, please.
Yes. Stay with me. I am having a little difficulty advancing the slide. There we go.
There we go. And so just so everyone knows, we have multiple forms of adoption in Maryland. We are going to be talking today about independent adoptions. And those are adoptions where we're not dealing with a state agency. We're not dealing with, someone who's been through a child and native assistance proceeding or anything like that. We're talking mostly about either step-parent adoptions or confirmatory adoptions, although we'll talk in a minute about how really we're not limited to those areas when it comes to independent adoptions, okay? But really we're talking about, generally speaking, consented to independent adoptions. Next slide, please. And so with respect to those independent adoptions, I want to be really clear that this is governed by Family Law Article 5, 3B 25. And after an adoption decree is issued for any of these three types of adoptions, but in particular for this one that we're talking about, the adoptee is legally the child of the adoptive parent, period, full stop. So all of the rights and benefits and privileges of a parent-child relationship attached. And if there is, we have two ways of doing this. In a step-parent adoption, if there is one parent who has consented to the adoption by virtue of the fact that it's their spouse, they will sort of keep their parentage rights to the child, right? And their spouse becomes the child's other natural parent or legal parent. But the former parent is completely divested of all of their parental rights. So that severs the parent-child relationship at that time. It also fully eliminates the obligations that may exist for child support, any rights that the child may otherwise have had to inherit from that prior parent, etc. It will not get rid of child support arrears. Those exist into the future. You can never discharge those. However, any ongoing obligations of support for a child go away. Any questions at this point? Okay. So let's talk a little bit about what these case captions look and where we file them. So there are a couple ways you can do this. I personally only ever put in the caption in re adoption of first name, last initial. Some people stylistically also want to put the petitioner on the caption. It's really your choice. And here we have a case caption that's a sample for the Circuit Court for Howard County, which is where I practice. And if we go to the next slide, venue where you file is always going to be in the prospective adoptee's domicile. I've had cases in the past where I have decided to file a motion to waive venue when there was some particular advantage to filing in a different venue. Years ago, it used to be that the Circuit Court for Baltimore City, for example, was a very friendly venue to doing step parent or confirmatory adoptions, second parent adoptions for same-sex couples. That's no longer really an issue across our venues. And so I don't tend to do that anymore. As a practical matter, I will say that I have had some difficulty in certain venues in terms of timeline and how long things take and how backed up the clerk's office is. So just be mindful that while venue is appropriate in the child's in the venue where the child is domiciled or the prospective adoptee is domiciled, you can also file a motion to waive venue and to move into a different venue. As for who can adopt, sorry, Nancy, just one second. If we go back.
I'm so sorry.
That's okay. Any adult can be the petitioner. Okay. Now, you don't want an adult petitioner to, for example, try to adopt their spouse. But the petitioner can be any adult, and the prospective adoptee does not have to be a minor. If you are doing a step parent adoption, so if the petitioner is married, well, two things. If the petitioner is married and they're adopting, you know, say a child of another, of a relative, for example, their spouse must join in the petition. And then if they are a step parent, then that spouse is not technically a co-petitioner. I usually file them as with the consent of their spouse, the natural parent. And you have to file the requisite consent form, which we'll talk about in a moment. But the point is that you don't have a spouse as a natural parent, as a co-petitioner for the adoption in traditional step parent adoptions. Does that make sense? Okay. All right. So in an uncontested adoption, what makes it uncontested is the fact that the child's parents, the natural parents, or, and I say child, we can, as he said, adopt an adult as well, but the natural parents must consent. And if the child is over 10 years old, they also must consent. If they are over 10 years old, then the court will likely, is required to, and we'll talk about it in a second, appoint an attorney for the child to explain the consent process, make sure that they understand that this person is going to become their parent, or these people are going to become their parents. And, you know, is that what you want? You know, how do you feel about them? Are you comfortable? It's sort of like a BIA role, except it's limited just really to the consent. So what does that mean? If the natural parents consent, and say, for example, you have a couple where it's a step-parent relationship, and bio dad is still in the picture, but is going to consent to the adoption. Maybe stepfather is in a better place on a day-to-day basis in terms of not only providing care for the child, but maybe bio dad wants to consent because he knows that this child is going to have much better rights in terms of inheritance and all that stuff. But bio dad says, you know what, I really want to continue to have some kind of relationship with this child. It's possible by virtue of executing a post-adoption contact agreement. And those agreements are binding. They're not custody orders per se, because again, the biological parent, when they consent to the adoption, once the adoption is finalized and the decree is issued, their parentage rights are severed. Right. However, they would still have contractual rights vis-a-vis the post-adoption contact agreement. Maybe it's I will get a letter in the mail every year on the child's birthday with photographs and this, that, and the other. Maybe it's once a month, I'll still be able to have a phone call, or I'll see the child, et cetera, et cetera. So those are the right to do that is contained within 53B07. And what I like to do is if I have a post-adoption contact agreement, I file it as part of the petition for the adoption. And in fact, if you do have one, you're required to do so. Okay. Questions about those agreements? No. As a practice pointer, sometimes it's beneficial if you have a parent who's been largely estranged, doesn't really have a relationship with the child, and you're not really sure how they're going to take a letter in the mail that says, hey, will you sign this consent to the adoption? Again, you have to walk a fine line because you can't give legal advice to pro se litigants who are, on the other side of this. But I have found that more often than not, including a proposal for a post-adoption contact agreement along with the consent form, when you mail it or when your client goes and talks to them about it, kind of helps, grease the wheels a little bit. If there are concerns about completely divesting that relationship and never knowing anything in the future or having any right to know anything in the future about the child. So that's just sort of from my experience, something that can be helpful. There are obviously circumstances in which it would never be appropriate to make that offer or to enter into an agreement on those terms. So, use your judgment, and obviously your clients will control. But just food for thought. Next slide, please. Okay, so we are going to go through the rule, and that rule is Maryland Rule 9103, and subsection B1 in particular contains everything that your adoption petition must include. Now, when I say must, not all of it will necessarily be applicable, but the basics are you need to have, first of all, basic information about the petitioners, where they reside, with whom, their marital status, any other children in the home, where they're employed, how long that they have been employed there, how long they've resided there, their income, right? So for example, going back to our Batman and Alfred example, right? Petitioner resides at Wayne Manor and has resided there since, May 1st of whatever year, with the child to be adopted or the prospective adoptee, Bruce Wayne, and anybody else that's in the home. Petitioner is gainfully employed as a personal assistant and house manager, earning, $150,000 a year, and has been employed since whatever date. Okay. that is the first thing. And so if you have co-petitioners, you need to include that information for both of them. And so I usually have the first paragraph that says that this is, petitioner 1 and then petitioner 2, right? And do it for both of them. And we'll get to this in a minute, but you include information about the income of the petitioners. And then as one of the exhibits, you're going to include actual verification of that income. So typically tax returns. And I want to be really clear, adoptions are filed under seal. So you don't need to do what you would ordinarily do when you file a financial statement or anything like that and file a notice of restricted information when you electronically file these on MDEC. That is not necessary. I still typically redact, the first portion of the Social Security numbers just because it makes clients more comfortable. But they are under seal. They are not subject to public inspection. Okay. The consent of both of the birth parents must be included. If you don't have the consent of one parent, what the court will do is issue a show cause order, put it, have you effectuate service, and give that other parent the 30 days, or if they're out of state, the 60 days to file their response as to whether or not they consent to the adoption. If they do not, then you are no longer in a consented to adoption, and we can have an entire separate presentation on what an uncontested adoption looks like. But assuming that you have the consent of both parents, you need to include those forms in your petition when you file it. Those forms are available online. Nancy, if you need samples, I'm happy to provide them through, for the participants. One other really important practice pointer, the consent form contains 2 parts that need to be signed and will get rejected. And unfortunately, I've had this happen where a parent signed just the consent portion at the end, but made the mistake of not signing the instructions page, which must be signed. They also need to have witnesses. It doesn't need to be notarized, but it needs to be witnessed by 2 people. And those people cannot be have any other relationship to the case, right? So I usually say, look, if it's a confirmatory adoption, we'll talk about those in a moment. Or if it's a step, just go to your neighbor's house, right? If it's, bio mom and stepdad and bio mom's consenting, just go next door, right? Have both your have your neighbors sign it. But make sure that they sign both the instruction sheet and the actual consent itself and have it witnessed. Failure to do that, and then again, what happens is, someone consented and then you say, hey, you forgot this part, please sign it. And now they're not willing to do it anymore. And, you kind of are stuck. So just be sure when you're getting those signed to do that. They can be revoked within 30 days of having signed them. I typically, as a practice point, don't file my adoption petitions until after the 30-day period has run. So if I get bio dad to sign on May 1st, I'm not going to file my petition until June 2nd. Okay. That way I know that I'm in a good place with that. The adoption also has to include the relationship between the parties. So if the petitioners are both the, aunt and uncle of the child to be adopted, or if this is an adult adoption and the prospective adoptee stands, is a longtime friend of, this third party, and the third party wants them to have inheritance rights. Whatever the relationship is, you have to define it in your petition for adoption. And then again, in terms of a statement as to how the child was located, often it speaks for itself in terms of, the child to be adopted is the stepchild of petitioner 1 and has known petitioner 1. So there's no locating the child, right? Otherwise, we have something called the interstate compact on adoptions. So if the child, for example, was in another state, there's an entire section of law, and the rules and the titles are all in the code. What we can talk about those, but you have to include a statement as to how these petitioners came to find the child. And finally, most importantly, you also need to have a history of all of the persons who've had care of the child, and have resided with the child. Again, assuming we're talking about a minor, since birth. So, just like you would include a 5-year history under the rules, if you're filing for, a custody action, you include similar information, but you have to go back from birth. And so, the minor child has been residing at these places, these people have cared for the child since his or her birth on date X, etc. Okay. 1 second before we go to the next slide. If there is not a joining of the spouse or a registered domestic partner of the petitioner, so say, for example, this is not like a stepchild per se, but some other relationship where one party in a marriage is petitioning to adopt and the other married person is not joining, you must include a statement in your petition as to why that person is not joining. So all of the requisite portions that must go into the petition are contained within that rule. Those are sort of the highlights. You also have to include that, if either petitioner has ever been convicted of a crime of, basically other than a minor traffic offense, if you want to change the person to be adopted's name, that needs to go in there. And also if there's any known disability pertaining to any of the petitioners or any of the parents. Okay. If there is, then the court may find a basis to appoint counsel for those people. Okay.
Miriam, there is one question.
Yes.
Geraldine has a question. Do these requirements apply for an adult adoptee? Do you still provide proof of income, etc.?
So most of them do apply for an adult adoptee, not the portion of how the child was located, is my reading of the rule. And yes, you would still provide verification of income. There is an exception to that, which we will get to in a minute when we talk about confirmatory adoptions. And I use that language to refer to adoptions that are pursuant to the Family Law Article 5(3)(b)(2)(7), which is adoptions for children who were conceived via assisted reproductive technology. And so typically those are, adoptions where we're inside of a marriage or inside of a partnership where there was consent to the use of reproductive technology. And so, we know that both of these people are the intended parents, both the natural parent and the person who used the ART, right? And we don't need that income verification then, but we'll talk about that in a minute. Does that answer your question? So, and if you look at the rule in particular, and again, it's 9103, it says, like, if the person to be adopted is a minor who has been transported, if applicable, the reason why the spouse or registered domestic partner is not joining, if there's a guardian with the right to consent, and so not everything in 9103B is going to be applicable in your case, right? And so just read it very carefully as you're going through your adoption. You may want to have like a form that has basically the rule in it, and you kind of go through and you do one and then the other, and if it's not relevant, you just delete it, right? That's how I like to do it so that I make sure I'm not missing anything. When you file these, there's an adoption clerk who's going to review them before passing them on to a judge to set a hearing, et cetera, like an uncontested hearing. I promise you, they will contact you if there's something missing. Your petition is missing this part. I need this exhibit still. They will get in touch with you. So it's not like if you miss something, it's not like it will fail to go through. You're just going to have to supplement your petition and include that. And so, it just drags it out a little bit is all. So do your best to sort of cross-check against the rule as you're going through. But in general, most of this is required irrespective of whether it's a minor or not a minor. Other questions about what the petition must include? Also, like, you have to include that, you're not aware, the petitioner's not aware that any required consent has been revoked, et cetera. Okay. So that is what must be included in terms of the petition, the contents of the language of the petition. There's also under 9103B2, a list of all the exhibits that must be attached. And the rule now, so initially it wasn't written so clearly, but the rule now specifically states these requirements are not applicable to the confirmatory adoptions that we'll talk about in a minute. Those adoptions require far fewer exhibits. Again, because the idea is that this is really functionally a child of both parties already under the Estates and Trust article. We'll talk about that, I promise. So we don't need as much for that. That child's already living with these people, they're married, etc. It was born during the marriage. But for all other adoptions, here are what you need. And so you're going to need the consent forms of all of the natural parents. If there is a deceased natural parent or, you know, a natural parent cannot be found, you're going to need to include an affidavit that said, you know, an affidavit of diligent search or a death certificate. You're going to need the birth certificate of the prospective adoptee. If you're doing a step parent adoption, you need their marriage certificate. If either party was married previously, you need their divorce decree. Okay. If there is any existing guardianship or custody order, you're going to need to include copies of those. The income verification. And then here's something that I have my clients do on their own before filing. It's not required until later for the child, but I like to get it all in there all at once. It's a health verification form. And it's very basic. I have a form and, you know, most doctor's office can do it. And it basically says, you know, petitioner's in good health. They, you know, have some minor blood pressure issues. They're fit, you know, and healthy to adopt this child. The child is up to date on all routine screenings. The child is healthy and of, you know, and doing well. That's it. You know, I've had cases where I have had clients who have health conditions, right? And so, you know, those need to be included. I've had cases where I had clients who had certain long-term viruses that they were living with, et cetera. And so that was included in the verification. But, you know, the point was that it does not impact their life and they're doing well, et cetera, et cetera. Okay. Questions about those things?
There is one question. How would the petitioner obtain a health verification for the child if they are not the bio parent?
So that's a great question. And so again, if we're talking about a step parent adoption, usually we just have the, you know, the natural parent who's living in that environment do it. Otherwise, it comes later as part of, you know, the court's process. The court will say, hey, I'm ordering this. And so you go ahead and do that. So I've not had a case where I needed the court to order it later. I've really only encountered this in terms of a step parent situation. So, you know, normally the natural parent who's living with the child takes the form to the child's pediatrician. Does that answer that? And if you scroll down in the rule, actually, hold on. Let's see. Sorry, 1 second, everyone. No, I apologize. So it says if you look under 9103B2, a brief statement of the health of each petitioner signed by a physician or other healthcare provider, if applicable, and a brief statement of the health of the child by a physician or other healthcare provider. So again, if you're doing a completely independent adoption and say, you know, the natural parents have some relationship with the adoptive or prospective adoptive parents, I would say, you know, have your clients talk to the natural parents and say, hey, you know, can you take the kid to the pediatrician? Usually there's already some sort of guardianship arrangement or something like that. I've not encountered a situation where there was like no legal relationship at all between in a consented adoption between the prospective adoptive parents and the existing child, or no family relationship or anything like that. right? So the other scenario that I can think of is, like I said, mom and dad are parents of the child who has been living with aunt and uncle for the past 3 years by consent, and there's been some sort of power of attorney or guardianship document or something, because those people need to be able to, you know, provide care for the child. So I've not had it come up that it needs to be, that there's some problem getting that form done. If you do, I would petition the court for some order granting, you know, the authority to have the child seen by a healthcare provider or something limited in that capacity, or to appoint some sort of guardian ad litem or something like that. That's not the word we use, but something akin to that. Order the parents to take the child something so that the petition can be complete. Okay, so here is a little bit more of the language from that rule. And what I will say is this: if you get to the last two at the bottom there, the proposed judgment of adoption and the Maryland Health Certificate of Adoption form. Let me tell you about the proposed judgment of adoption. There are no local rules, as everyone knows, in our courts, but you need to know the local rules. So I have consistently found that the Circuit Court for Montgomery County, for example, has their own adoption decrees, their own judgment of adoptions. And no matter how many times I include a proposed judgment of adoption, the one that's entered by the court is never mine. And so do with that what you will. I personally like to prepare my proposed judgments of adoption anyway, because I like to include certain language and make sure all the stuff about what I want the court's findings to have been, et cetera, are all in there, so that there's everything's nice and clean. But you may find that you file one with the court and the court enters their own anyway. So just a little piece of information. The Maryland Health Certificate of Adoption form is available online, and it's kind of like the blue form that we use for divorces, right? So it includes all the vital information about the child who's being adopted, or not child who's being adopted, the parents of origin, the adoptive parents, etc. Right. And so you're going to need social security numbers. If you look at that form online, you'll see all the information that you need. So make sure when you're doing your intake process with your clients, I like to have them fill that out to begin with. Has their dates of birth, all of that stuff. And you're going to need that for your petition anyway, not their socials. And often you'll have that on the tax returns anyway, that sort of thing. But if you're doing a confirmatory adoption, you might not necessarily have it. So just make sure when you're doing your intake, I like to have my clients complete that up front. Okay. All right. So these numbers are not all exactly, they don't correspond to the numbers in 9103B2, but I just wanted to enumerate like the big ones, right? So just remember that if you're doing a step parent adoption, you need the marriage certificate. If you're doing you know, and you need divorce decrees from prior relationships. If the child was between mom and bio dad and they divorced, you need that divorce decree. And if there was a custody order to mom, you need all of that. Okay. Questions about the required exhibits? Okay. You're all here doing this training through MBLS, so I want to remind you that you can, you know, apply to waive the filing fees and costs. And so that is the court's form. If you're doing this through MBLS, I'm sure they will help you with that process if you need additional assistance. But otherwise, the the filing fee, I think it's the $165, and if there's an attorney appearance fee, the $10 or $20, depending on where you are. Okay.
And I might add that if you, if any of you are taking MBLS cases that require some additional fees, you can always go through, if we do not, if the court will not honor it through this prepaid cost or final cost, you can always call the litigation fund for the Pro Bono Resource Center, and they will honor generally your request for other fees.
Okay, great. Okay. So we touched on this briefly earlier, but I just want to be really clear. If a parent has a disability, and again, we're talking about a natural parent. So, if it's a step parent adoption, it would be your client's spouse, right? Or it could be the other natural parent if there's a disability, or if the parent is a minor, okay, then they will need counsel. And also the prospective adoptee, same reasons if there's any sort of disability. And also if the child is 10 years old or older, they must consent to the adoption and they need counsel for that consent. Questions? Okay. All right, so these are the confirmatory adoptions. And when I file these, I always put in the caption, or not in the caption, when I write the petition, right? I will always say petition for adoption, parentheses 53B27. Petition for confirmatory adoption pursuant to 53B27, something to signal to the adoption clerk who's reviewing this. This is different than the other adoptions. And I will tell you that even though this rule has changed and the code has been updated to reflect that you don't need all of the exhibits and you don't need a hearing, and we'll talk about all that in a minute. It has been my experience that in some venues I've needed to educate the clerks or educate, frankly, the bench. And so just remember, if you're doing these, you want to make sure that you've reviewed it and you know what is and is not required so that your clients are not put through a process that's more onerous than our General Assembly has contemplated and our Rules Committee has contemplated as necessary. Okay. And so again, these are what I call confirmatory adoptions. And the reason that we call them confirmatory adoptions is, again, if you think about it, this is already a child that exists in the home, that was born to both parties, right? That was conceived with the intention of both parents being the parent. And so really when we're going through and especially if they're already married under the Estates and Trusts article, they are already parents by operation of law, right? But belts and suspenders, portability issues, full faith and credit granted to a decree or a judgment from a court, right? Both parties will still be full legal parents no matter where they go, right? Once the adoption decree is issued. So that's why we do these. And so those are applicable to an adoptee whose individual is either the spouse of the prospective adoptee's mother at the time of conception or birth. And again, it does not need to be both. It can be either. Or an individual who together with the prospective adoptee's mother consented to the conception of the prospective adoptee by means of ART and with an express intent of becoming parents. So this is really close to sort of an intended parent standard, right? And again, these are only consented to adoptions. When I file these, I do usually break the traditional rule of not also filing with a co-petitioner when the co-petitioner is the parent. I usually file it as petitioner 1 and petitioner 2, who is the natural parent and also consents to the adoption, because we're really in this, like both of them are already parents land. Does that make sense? Okay. Anyone have any questions about who this adoption applies to, these types of adoptions?
I don't see any questions on that particular topic, but there is a question regarding whether or not the court appoints counsel for the minor child 10 and older.
Yes. So generally, yes. Now, if I have an attorney, if I'm trying to file everything together, sometimes I'll reach out to counsel and I'll say, hey, do you have room to take this on? I've got an adoption case, like, would you do it? And then I'll file a motion with the court to appoint the person who, I've already sort of said is available to do this work. But it's one or the other. You don't have to take that step. If I do, then basically what I do is that person's already kind of met with the child, submitted the consent, you can kind of file it all as one packet, right? But more traditionally, you file, you say that, we anticipate the child will consent, the child's over the age of 10, counsel needs to be appointed, etc. I don't usually file a separate motion within the, when filing the petition. In those cases, the court does it sua sponte. But I usually will say, petitioners anticipate that the child will consent, the child is over the age of 10 and therefore entitled to counsel in this matter. Okay. Okay, so for these confirmatory adoptions, you need, if they're married, the marriage certificate. And if they're not married, then you need some statement. I usually do it as an affidavit that both parties, complete kind of mirror affidavits of the express intention that was shared between them to, conceive of this child and both be parents. And sometimes I include, so you need the child's birth certificate, and then this is the kicker. This is section 3, and this really depends on who you go before. I have tried to pare down and make as bare bones as possible, because I think the concept under the rule is that we don't need to explain all of the nitty-gritty about everything and how this child came to be. But something that says that this child was conceived via ART, right? So the parties conceived the child via assisted reproductive technology by use of petitioner 1's egg and sperm from an unknown donor, an anonymous donor, right? And then petitioner 2 carried the child who is the subject of this adoption to term by virtue of in vitro. There are no other persons who are entitled to consent, right? Like the donor was anonymous and terminated their rights at the sperm bank because it was anonymous donor sperm from Fairfax Cryo. So there's no one else, there's no biodad out there who, needs to know about this petition. So that's really it. That's how I do it. If there was a known donor, then you would want to, if there was a donor agreement or those kinds of things, you would want to include all of that as well. More nuanced area of, how these can be done. But again, the concept is we just want to be sure that there's no one else out there who is a prospective parent who needs to consent to this because their rights are going to be terminated. And we also just want to be sure that we know how this child came to be. And so we just kind of do like a little bit of a chain of custody on that. It used to be that you would want to have like the insemination letter from the OB if they were using intrauterine insemination, or the letter from and the letter from Fairfax Cryo that said, I gave the donor sperm to Dr. So-and-so who, and now you have the letter from Dr. So-and-so who then did the insemination. Or from Shady Grove Fertility that, they were patients and they used this person's egg and this anonymous donor sperm, and then that was implanted into, the other mom, right? We don't do that anymore, fortunately, and I've not had courts require it under this new statute. Questions? Okay. So, and here's the other thing, and we'll talk about the non-confirmatory adoptions, like the step parent and other independent adoptions, which do result in a hearing, and it's very brief and happy, and we'll talk about those in a minute. But for these confirmatory adoptions, the court may not require, except for good cause, a home study or an adoption hearing. The court must find good cause for either of those things. And again, the concept is we're confirming that these people are both parents and no one's parentage rights are being terminated in the process of this. So we don't need to do any of that. And we don't need to drag people to court to adopt their own child who's already their own child. We'll just issue the decree after we're satisfied that everything's there. The court may hold a hearing if the court deems that there needs to be a determination as to if there are any other individuals who need notice, right? So if the court's not satisfied that donor John really terminated his rights when he made the donation of the gametes that resulted in this child, if the court's just not satisfied from the pleadings, that that person does not require notice, then the court can set any hearing. Otherwise, there needs to be good cause. And that hearing's different than the adoption hearing we're talking about, right? That hearing is just a hearing on, tell me more about how this process came to be and who donated and how, is there anyone else, just so that the court's satisfied that there's no other notice requirements or consent that needs to be given. Okay. I will again tell you, as a practical matter, I had an adoption pending in the circuit court for Prince George's County for months. It was stuck in the queue. I could not get anyone to review it. I raised hell, frankly, including to the administrative judge. And ultimately, it was finally reviewed and finally passed up, to be set for a hearing, which is just their process of how they move the petitions along. But no one had noticed that this was exempt from that hearing requirement. Rather than start my clients all the way back at the beginning and, maybe eat another 6 months in time before this adoption went through, we went ahead and showed up for the hearing. And the judge decided that even though this was a 5-3B27 adoption, since everyone was there, why don't we go ahead and put on testimony on the record, which was frustrating. But again, we wanted to get it done. And so we just moved forward. We put on some brief testimony that this was how the child was. Basically, we mirrored the language in the petition and, we got our decree that day. So just a practice pointer. I had another case where the petition did not linger indefinitely, but the court said, hey, you don't have the required, tax filings. I don't have any evidence of your income. And I had to, file a motion for reconsideration saying it's not necessary. We don't need that now. Okay. So, I think some of that's settling it down. I want to say it was 2021 when the new rule went into effect, but anyway. All right. Any questions about this part? Next slide. So if you are not under a confirmatory adoption, the court will, once everything's reviewed and the clerk passes it up to a judge and everything looks good, you'll get a hearing notice. And they're a brief proceeding. They're one of the few times when you can actually, with the court's permission, of course, take a photograph in the courtroom. And they're very sweet proceedings. And you'll see, there's usually, they do them kind of like on Fridays all together with like a bunch of folks is commonly how it's done in some courts. And it's, brief and it's, hi, so glad to see you. You must be Mr., you must be Ms. And this must be, young Master Wayne, right? And so lovely to see you all. Everything appears to be in order and congratulations. It's really brief. It's usually a pretty pro forma just to sort of lay eyes and say, you're who you say you are, you're who you say you are. Child, you seem pretty happy, or not child, you've consented to this. Okay. And so that's that. When you draft your decrees of adoption, assuming that you do include them, I always include language that says that the child's name or the adoptee's name is going to be changed from this to this, and that the Department of Health and Mental Hygiene is directed to prepare and issue a new birth certificate. I will also include, changing the father from Bruce Penny, from the father of origin to the adopted father. Okay. If there is, if there are parentage rights that are being terminated, then you also include the language that so-and-so is hereby declared to their rights are terminated. They're no longer considered to be a parent or father of this child. Okay. Again, it doesn't matter if you're filing in Montgomery County, they're going to draft their own anyway. I think everyone is clear on this, but I just want to be really sure, right? So custody can be modified, guardianship can grant some, decision-making authority or power of attorney kind of things, but adoptions confer full rights and obligations, right? If an adoptive step parent ultimately separates or divorces from, the other natural parent, they have a support obligation, right? The child has the right to inherit under our intestacy laws. They are full legal parents with all the benefits that come with it and all of the obligations. And again, while you can sort of modify custody based on a material change, and I've never had an adoption appeal. I don't know I can't think of an example where, unless there was really like a fundamental error in due process, like if all of the, I would think that most of them would be under, contested adoptions, not uncontested adoptions, right? Otherwise, it's a final court order. It's the subject to the same revisory power of the court under any other, under the rule for any other civil decree. And so you would have the same obligations to note and appeal quickly. And again, I can only think of that as happening under really a contested circumstance where there's been a trial. Or if someone did not get notice and had the rights and there was some fundamental error of law. Questions about, just trying to see if there's anything else I had notes on. I think that's it for me. I know, Nancy, you have some other points on MBLS, and I know I've left us with about 5 minutes, but.
Well, that's fine. I thank you for this. It was so informative. I do have a question on this last slide, though.
Sure.
It's, a guardianship versus custody versus adoption, all of these things can get sort of muddled together, and many clients don't really know what they want to do when they find themselves in a situation. What would, I know this is probably too broad and maybe I need a few more facts for this. I think I do personally, but I have a client who is applying for services where she is wanting to file for guardianship, custody, or adoption, and both parents are deceased. The question is, which is the best route? I'm leaning toward custody, but I'm not sure that's the best thing to do when, at this point, third-party custody, perhaps.
I think so. Like any good lawyer, I'm going to tell you it depends.
It depends.
It depends. I think I don't know what sort of state benefits there may be to this client in assuming either custodial or full parentage rights as an adoptive parent might be. That's something to consider. I would need to do a little bit more research on that.
Yeah, I intend to.
Yeah.
I was just stumped by it at the initial look-see at it, and I saw that they were both deceased. It was like, some require consent of one or both parents when there's not both parents, which is a better way to do it.
Right. Right.
So I just thought I'd bring that up. There's all kinds of different situations that could come up in any of our practices where we're faced with something like this. So if I need any other help, I'll give you a buzz, but.
Sounds good. Yeah. And I would say, look, I do think that there are circumstances where, there are all kinds of kinship arrangements, right? Where like people are not really able to provide care for their child directly, and an aunt or a sister or a grandmother steps in, and there's sort of this informal relationship. And the question is sort of, well, what are we going to do about school? What do I do if I need to go to the doctor, right? Like, what do I do under these circumstances? And so, I've had cases where we try to sort of gently, for now, put something in place that puts my clients in a good position if something is going to happen, or there's going to be a request to sort of change things back down the road, right? So maybe there's some sort of like softly worded agreement that's not so soft, right? It says that like they agree that grandma and grandpa will have care and custody of the child and have the rights to make decisions for the child, including, medical and educational and all kinds of other major decisions for the child. And so we do that. We incorporate it as a consent order, into a court, in whatever court is, the appropriate venue. So maybe there's no support obligation or something like that included there, but we have something. And then if that parent comes back and says, I want to take Charlie with me, well, no, we have a court order now, right? So we don't just have an agreement, we have a court order.
Right.
And then if that parent sleeps on their rights and has no contact for years and is really MIA, then the clients are in a much better position should they choose to adopt the child. Now, again, if they do that, they will have a support obligation to that child if anything happens between them, et cetera, et cetera. So there may be reasons why they want the natural parent to have a support obligation and not them, or what have you, right? It depends. But having some sort of like custodial arrangement, I think in many of these cases is sort of a good starting point, because more likely than not, you're going to get the family member to sign that document rather than starting with, hey, terminate your parental rights.
Right.
So as a practical matter, folks are usually more amenable to, hey, I don't really have adequate housing right now and I'm not employed, my life's really unstable. Yes, you take them and you have that language and you can incorporate that as a consent order or whatever, or file it even as not a consent order. Maybe you get a default on it, right? But then there's a court order rather than trying to get immediately. And again, it depends on the circumstance.
That's
if
very
everyone's
helpful.
it depends. So
thank you for that.
You're welcome.
I want to thank you so much, Miriam, for being here. I really can't tell you how much it means to us. We've needed this for a long time. I do want to tell the panel, the participants, that we are always seeking volunteers. Just a reminder for the Judicare panel. As you know, you're compensated if you are a member of our panel. For anyone who is on this program and is not a Judicare panel member, I ask that you contact me and let me know if you are interested, and we can work on getting you on board. And if you'd just like to visit our website and take a look around and visit the portal and see what kind of cases there are out there, you can certainly do that in the meantime. I do thank you all for being here today and for taking time out of your busy schedules. Thank you, Miriam.
You're very welcome. Thank you all.
And I will make sure that every participant has a copy of the recording and the PowerPoint. It'll take a couple of days, but I will make sure that you all get a copy.
Sounds good. And if anyone has any additional questions, my contact information is included in the slides. Please don't hesitate to reach out to me.
All right. Thank you so much, everyone. Have a wonderful day. Have a wonderful weekend and enjoy the nice weather.
Great. Thanks, everyone.
Thank you. Bye-bye. Marion, you good?
I'm good. I'm good.
Thank you. That was great.
Of course. Wonderful. All right. It's so hard, right? I never know if I'm just talking too much.
It was very nice. I thank you, and thank you for asking my question for me. I will get back to you on that if I get some more information.
Absolutely.
Should I stop? But my thoughts were the same as yours, so that's good.
Yeah. Well, feel free to be in touch. Happy to be a resource.
I will. Thank you.
Take care.
Bye-bye now.
Love you.